Ever feel like you're drowning in information? Trying to grasp a complex situation, needing answers fast, but not wanting to get bogged down in all the details.
Yeah, absolutely. I think we've all been there.
Well, today we're all about clarity, cutting through the noise and getting straight to what matters. We're diving deep into a legal case that has huge implications, especially when you're talking about industries like construction, where time is money and disputes need resolving quickly. It's a UK case, Cantillon Limited versus Urvasco Limited, and it dates back to 2008.
Okay, Cantillon versus Urvasco. Sounds like a clash of the titans.
It kind of was, in a legal sense, and it's a landmark case because it really clarifies why UK courts almost always uphold the decisions made by these rapid dispute solvers, adjudicators, those folks who come in and make a binding decision quickly to keep things moving.
Adjudicators, right. They're kind of like referees in the middle of a construction project brawl, trying to make a quick call and keep things from completely falling apart.
Exactly. And this case, it's officially cited as 2008 EWHC 282 TCC. Just in case you want to look up the full judgment yourself. But don't worry, we're going to break it all down for you. It's a fascinating story, really. A construction project goes south, an adjudicator steps in to make a ruling, and then one of the parties tries to fight back in court, arguing that the adjudicator got it wrong.
So it's like a legal tug-of-war with the adjudicator in the middle.
Yeah, and this legal battle, what's really interesting is that it highlights some really fundamental principles about how much authority these adjudicators actually have and when their decisions are going to hold up under scrutiny by the courts. And crucially, it emphasizes just how important fairness is throughout the adjudication process.
Fairness. Got it. So even though it's meant to be quick, it still has to be a fair fight.
Absolutely. Think of this as your crash course in this vital area of construction law. Our goal today is to really pull out those key lessons from Cantillon versus Urvasco, particularly what it tells us about the power of adjudicators, the importance of due process and fairness, and what this all means if you ever find yourself facing a similar situation. Because let's be honest, these types of disputes happen all the time, don't they?
All the time. Construction projects, there's always something to disagree about. So where do we begin with this Cantillon versus Urvasco saga?
All right, well, let's set the scene. We've got Cantillon, the contractor, and Urvasco, the employer. They signed a contract for a pretty big job demolition, piling, all those heavy-duty construction tasks. This was happening at a site on the Strand in London, pretty prime real estate.
A Strand, fancy.
Yeah, not your average backyard project. And for the contract, they used a standard form of JCT contract. That's pretty common in the UK construction industry.
Right, JCT, I've heard of those.
Well, as you'd expect with these JCT contracts, it included a clause about using adjudication to resolve disputes. The whole point is to deal with disagreements quickly without letting things drag on forever in court.
Makes sense. Time is money, as they say.
Absolutely. But as often happens on big construction projects, things don't always go exactly according to plan. Disagreements cropped up, tensions rose, and this is where the real story begins.
Uh-oh. Sounds like trouble brewing. What were they fighting about?
Okay, so the main bones of contention were Cantillon's claims for extensions of time and associated costs. Basically, they were saying, hey, we need more time to finish the work, and we're going to need more money because of these delays.
Classic construction dispute. Happens all the time.
All the time. And we're looking at two main claims here. One was for a 16-week extension, and the other was for a 13-week extension.
Okay, so a decent chunk of time, and I'm guessing a decent chunk of money, too.
Yeah, you got it. So to sort out this mess, they brought in an adjudicator. Now, he reviewed all the documents, held a couple of meetings, heard both sides of the story, and in November 2007, he issued his decision.
The adjudicator's ruling, the moment of truth. So who won?
Well, the adjudicator awarded Cantillon a hefty sum, £391,565.60 plus VAT.
Wow, that's a lot of pounds.
It is. Now, this was actually less than what Cantillon had initially claimed, but still a significant victory for them. And it's worth noting that about a fifth of that total award was specifically tied to that 13-week extension claim.
Gotcha. So Cantillon's probably pretty happy at this point.
Yeah.
But something tells me Urvasco wasn't quite ready to throw in the towel.
You're reading my mind. You see, Urvasco, they weren't thrilled with the outcome, and they weren't about to just accept defeat. They decided to challenge the enforcement of the adjudicator's decision in court.
Oh, taking it to the next level. I guess they must have had some pretty strong arguments up their sleeve. What were they claiming?
They did, and they essentially launched a two-pronged attack. Their first line of argument was that the adjudicator had overstepped his authority, that he didn't have the jurisdiction to make the decisions he did, especially regarding that 13-week claim.
Okay, challenging the adjudicator's power. Interesting. And what was their second point?
Their second argument focused on the concept of natural justice. Basically, they claimed that the process had been unfair, that they hadn't been given a proper chance to present their side of the story, especially when it came to that 13-week claim.
Natural justice. So even in these fast-track adjudications, there's still an expectation of fairness. I like that.
Yeah, it's a crucial principle.
Yeah.
And this whole natural justice argument, it really zeroed in on that 13-week claim. Urvasco argued that the way the adjudicator dealt with that specific claim had been fundamentally unfair to them.
I see. So let's dig into those arguments one by one. First up, the jurisdiction challenge. Urvasco was saying the adjudicator went beyond what he was allowed to decide. What did the court think about that?
Okay, so the judge in this case was Mr. Justice Aikenhead. He's a big name in construction law. And his view was that the heart of the 13-week claim was, without a doubt, about the losses Cantillon claimed to have suffered because of that 13-week extension of time granted for the piling variation. That much was clear. And that core issue, it was definitely within the scope of what was referred to the adjudicator.
Right. So at the very least, the adjudicator was allowed to look at that 13-week claim. But Urvasco was unhappy about how he handled it, specifically about the costs.
Exactly. Urvasco's argument was essentially, look, Cantillon asked for costs related to a specific 13-week period, claiming it was all down to this change in the piling work. But the adjudicator ended up awarding costs for a totally different time frame, a period that came later in the project.
Ah, so the adjudicator shifted the goalposts, so to speak.
That was their claim, and they argued that they were never given a proper opportunity to present evidence about the costs that might have been incurred during that later period. They felt blindsided.
I see. So they're saying, hold on, we weren't prepared to argue about the costs for that time period.
Exactly. And here's where things get really interesting. And this is a crucial lesson for anyone involved in these kinds of disputes. You see, Urvasco themselves actually played a significant role in shifting the focus to this later period.
Wait, how did they do that? They were arguing against the adjudicator's decision.
It's almost ironic. You see, as part of their defense, Urvasco had argued that any delays, and therefore any costs associated with those delays, actually happened later than the period Cantillon had claimed for. They based this argument on the as-built schedule, the record of what actually happened on the project compared to the initial plan.
So they were saying even if there were delays, they didn't happen when Cantillon said they did.
Precisely. So in essence, Urvasco was saying, look, even if we accept that there were delays caused by this piling issue, those delays actually occurred at a different time, much later in the project. So the costs that Cantillon is claiming for that earlier 13-week period are simply wrong.
I'm starting to see how this might have backfired on them.
Oh, it absolutely did. And this is where the judge's reasoning gets super interesting, really insightful. He basically said that once Urvasco put forward that argument, that the relevant delays and costs actually happened later, well, that opened the door for the adjudicator to consider that later period.
It's like they inadvertently expanded the scope of what the adjudicator could look at.
Exactly. And the judge, he had a rather memorable way of putting it. He said, it offends reason that Urvasco could run that defense and avoid the consequences.
Wow. Yeah, that's a pretty strong statement.
Yeah.
So even though Cantillon initially framed their claim around a specific 13-week period, because Urvasco brought up this alternative timeline in their defense, the adjudicator wasn't overstepping his authority by considering that different time frame.
You got it. It's a crucial point. And to be clear, the judge also made a point of saying that Urvasco didn't actually dispute the adjudicator's fundamental power, his jurisdiction, to deal with the 13-week claim itself. Their argument wasn't, he shouldn't have been looking at that extension of time at all.
Right, so they weren't saying he was completely out of bounds. Their argument was more about the specifics of when those costs were incurred.
Exactly. They were essentially saying the costs Cantillon is claiming are wrong, and they're wrong for two reasons. One, they weren't actually caused by the piling variation, and two, even if they were, they occurred at a different time than what Cantillon initially claimed.
Got it. Okay, so that settles the jurisdiction issue.
Mm.
Now let's talk about that second argument, natural justice, the fairness of the process. Urvasco felt they hadn't been given a proper chance to present their side of the story, particularly regarding the costs for that later period the adjudicator ended up focusing on.
Right, so they were essentially saying, we prepared our arguments and evidence based on the specific 13 weeks that Cantillon initially claimed. We didn't have a fair opportunity to submit detailed cost information for this other period that the adjudicator ultimately used to make his decision.
Sounds like a valid concern.
Yeah.
It would be fair if they were caught completely off guard.
You'd think so, right. But the judge, he didn't agree. He meticulously reviewed the whole timeline of the adjudication process, all the back and forth between the parties, all the submissions, and he pointed out that Urvasco did actually have the opportunity to submit information about those costs.
Really? But they claimed they were blindsided.
They did, but here's the thing. The judge noted that in their initial referral to the adjudicator, Cantillon actually provided cost information that wasn't limited to just those 13 weeks they were initially claiming for. They'd actually given cost details that covered a wider time frame.
So the information was there,
Yeah.
just buried within a broader set of cost data.
Exactly. The raw data was there, even though it wasn't presented in a way that was specific to that later period. And the judge also highlighted a crucial moment in the timeline. On October 23, 2007, Cantillon specifically asked the adjudicator to assess the losses based on the actual delay period that he determined had occurred.
Interesting. So they were essentially saying, look at the actual delay, whatever you decide that is, and then calculate the cost based on that delay period, even if it's different from the 13 weeks we initially claimed.
Precisely. And the judge reasoned that this request should have alerted Urvasco to the possibility that the adjudicator might end up looking at a different time frame when calculating the costs.
Makes sense. If Cantillon is saying use the actual delay, even if it's different, then that should have been a red flag for Urvasco.
Exactly. It's like a heads up, right? Hey, things might shift a bit, so be prepared.
Yeah.
And here's the clincher. Urvasco chose not to submit any additional cost information, even though they had time and the chance to do so.
So they had the opportunity to bolster their arguments with more specific cost data. For that later period, they were given a heads up that this period might become relevant, but they didn't take advantage of it.
You got it. And the judge, he explicitly concluded that this decision by Urvasco did not constitute a breach of natural justice.
So in the judge's eyes, the adjudicator had acted fairly. Urvasco had a chance to present their case fully, and they didn't take it.
Exactly. And, there's another important legal principle at play here. The judge also touched on the idea that if an adjudicator makes a mistake, maybe they get a fact wrong or they misinterpret a bit of law, that in itself is generally not enough to overturn their decision.
That's really interesting. So adjudicators are allowed to be human, so to speak.
To a certain extent, yes. The courts acknowledge that adjudication is meant to be a fast process, and it's not intended to be a perfect process in the same way that a full-blown court trial would be.
Right. It's more about getting a quick, workable solution rather than a meticulously perfect one.
Exactly. The goal is to keep things moving. And that's why minor errors in an adjudicator's decision, they generally won't be enough to have it completely thrown out. The legal bar is much higher. You need to show a clear lack of jurisdiction or a really significant breach of those natural justice principles.
Okay, that makes sense. So this case, it seems to be pointing towards a really strong tendency for the courts to uphold these adjudicator decisions. Did the judge specifically address that?
He did. Mr. Justice Aikenhead, he made it crystal clear that the courts have a very strong preference for enforcing adjudicator decisions. He basically said that the courts should only really step in rare circumstances, when there's a blatant error in jurisdiction or serious demonstrable breach of natural justice.
It sounds like they really want to give adjudicators the benefit of the doubt.
Yeah, the system relies on that trust, right? And, the judge even quoted a line from an earlier case to emphasize this point. He said the courts shouldn't encourage parties who are just scrabbling around to find some argument, however tenuous, to resist payment.
Scrabbling around. I love that. He doesn't mince his words.
No, he doesn't. And it highlights just how important the courts consider this quick and effective resolution process to be, especially for something like construction where cash flow is so critical. The whole point of adjudication is to get things resolved swiftly, even if it's not perfect, to keep those projects moving.
Yeah, that makes a lot of sense. If the courts were constantly picking apart every adjudicator's decision, the whole system would grind to a halt.
Exactly. It would completely undermine the purpose of adjudication. Now, there was another interesting point that came up in the judgment, almost like a side note, but worth talking about. It's the concept of severability.
Severability. Now, that's a mouthful. What does that even mean?
So severability in this context refers to whether certain parts of an adjudicator's decision can still be enforced, even if other parts of that decision are found to be flawed.
Okay, so imagine an adjudicator makes a ruling that covers several different claims or issues. Could some parts of that decision still be valid, even if other parts are found to be problematic?
That's exactly it. So let's say a court later finds that there was a jurisdictional error or a breach of natural justice that affected only one specific part of the adjudicator's decision. The question then becomes, can you separate the good parts from the bad parts, so to speak? Can the rest of the decision still be enforced?
That's a tricky one. So what does the judge have to say about that?
Well, he noted that there wasn't a lot of legal precedent at the time, specifically on severability in the context of adjudication. But he did offer his own thoughts on how it might work, which carry a lot of weight even though they weren't strictly binding in this particular case.
Okay, interesting. So what were his thoughts? Under what circumstances might you be able to sever the good bits from the bad bits of an adjudicator's decision?
He suggested a few key things to consider. First, you really have to look at what specific disputes were actually referred to the adjudicator in the first place. Were they truly separate, distinct disputes, or was it basically one big, overarching dispute with various interconnected elements?
So, were they dealing with multiple separate arguments or just different aspects of the same fundamental disagreement?
Exactly. And if there are clearly multiple separate disputes referred, then a problem with the adjudicator's decision on one of those might not necessarily invalidate the decisions made on the others. It would be like saying, okay, they messed up on this one issue, but the rest of the decision still stands because it relates to completely separate matters.
That makes sense. If they're totally independent issues, then why should a problem with one automatically taint the others?
Precisely. And the same logic would apply if a breach of natural justice only affected the adjudicator's handling of one specific self-contained dispute. But the judge also cautioned that if the adjudicator's decision is not realistically severable, if the different parts are so interconnected that you can't really separate them, then the whole thing might be unenforceable.
So it's like a tangled web. If you pull on one thread, the whole thing might unravel.
Yeah. Exactly. And similarly, if the breach of natural justice was so fundamental and widespread that it casts doubt on the entire decision-making process, well, then the whole thing might have to be thrown out. It's like saying the process was so fundamentally flawed that we can't trust any of the conclusions.
Okay, I'm starting to see the nuances here. It's not always black and white.
No, it's definitely not. And the judge also made an interesting point about cases where only a single dispute was referred to the adjudicator. He said, look, if they make a significant error in how they handle that one dispute, you can't really pick and choose which parts of their findings you like and which you want to disregard.
So it's all or nothing in those cases. You can't cherry pick the bits you agree with.
Right. And going back to Cantillon versus Urvasco, what was interesting was that the judge actually hinted at how he might have approached severability if he had found a problem with the 13-week claim.
Oh, so even though he ultimately ruled in favor of enforcing the whole decision, he still entertained the idea of severability.
He did. He said that if, hypothetically, there had been a breach of natural justice that specifically affected the 13-week claim, he probably would have enforced the rest of the adjudicator's decision, the part that dealt with that separate 16-week claim.
Because he saw those two claims as distinct issues.
Exactly. He viewed those two claims as logically and chronologically separate, dealing with different periods of delay and different underlying causes. And importantly, the financial aspects of those two claims were also clearly divisible. So in that particular scenario, severability might have been an option.
Gotcha. So even though severability wasn't the deciding factor in this case, it's still really helpful to know how the court might approach it in situations where multiple, potentially independent issues are at play.
Absolutely. It's a really important takeaway for anyone who might find themselves dealing with these complex adjudicator decisions. So, as we start wrapping up our deep dive into Cantillon versus Urvasco, what would you say is the most important lesson here?
I'd say the key takeaway is this. The UK courts, they have a very strong bias towards upholding decisions made by adjudicators. Unless there's a clear and substantial issue with the adjudicator's jurisdiction or a major lack of fairness in the process, chances are the courts are going to back the adjudicator's decision.
And Cantillon versus Urvasco really underscores that if you're involved in an adjudication, you need to be all in. You need to present all your arguments, all your evidence in a clear and comprehensive way. You can't just sit back and hope to find a loophole later.
Yeah. Or inadvertently hand your opponent ammunition by introducing arguments that might broaden the scope of what the adjudicator considers. Remember that line from the judge. It offends reason that Urvasco could run that defense and avoid the consequences.
Powerful stuff. So the message is clear. Engage actively, present your best case, and don't expect the courts to bail you out unless there are really compelling legal grounds to do so.
Right. And that whole discussion about severability, even though it wasn't central to the outcome of this particular case, it still gives us valuable insight into how courts might approach enforcing those more complex adjudication decisions, those decisions that deal with multiple claims or issues.
Exactly. It highlights the fact that how you structure your arguments, how the adjudicator deals with those different aspects, it can all have a real impact on whether their decision will hold up if parts of it are later challenged.
Absolutely. So I guess the big question that this case really leaves us with is this. Adjudication is meant to be fast, right? And sometimes, because of that speed, it might not always be perfect.
Right.
But how does that balance with the need for fair and accurate dispute resolution, especially in an industry like construction where so much is at stake? It's that classic tension between speed and getting things absolutely right.
Yeah, it's a fascinating dilemma, isn't it? And I think that's something for all of us to ponder. This case definitely emphasizes the importance of participating fully in the adjudication process, putting your best foot forward because the courts are unlikely to give you a second chance. And it certainly makes you think about the wider implications for project timelines, for the financial well-being of everyone involved, and for fairness in dispute resolution within the construction world.
Absolutely. It's a reminder that in construction, just like in law, the details really matter.
They really do. Well, on that note, we'll wrap up this deep dive. Thanks for joining us, and until next time, stay curious and keep building.
See you next time.